Hello, and welcome to the Arbitration Conversation. So in this webisode, we're going to talk about construction arbitration. Construction arbitration is a very popular area for a very long time. Construction cases have gone to arbitration, mainly because arbitration clauses are built into the standard contracts for many, many construction projects. So I'm very delighted that in this webisode, I have a true expert in construction law here to talk about the topic. This is an attorney in Chicago, Clifford Shapiro, but he's also an arbitrator, a mediator, and he's a partner in a law firm where he's specifically focusing on construction law. So first of all, thank you so much, Cliff, for being here with us.
Well, thank you, Amy, for inviting me. It's a real pleasure to be here.
Well, so I guess first of all, if you could just provide a little bit of background about sort of how it works with construction arbitration, what your experience has been, to kind of get us into the discussion.
Yeah, well, you know, I've been doing this about 36 years, and I've probably been focusing almost exclusively on construction for about 25 to 30 of those years. And what you said is right. Construction lends itself to arbitration in part because the construction industry many years ago was one of the industries that was at the forefront of using arbitration to resolve disputes. And that's still the case. As a practitioner, one of the things I found that was interesting and sometimes troubling was when you get into a construction case that has a lot of different parties and a lot of different claims, arbitration can work well, but I think, and this is one of the things I think we'll talk about today, is that you know, whether you can really get everybody into an arbitration proceeding is sometimes problematic, because unlike going to court, an arbitration agreement is by agreement. And you can only force someone to arbitrate, or you can only take advantage of arbitration if it's actually contractually agreed to. And so that can be an issue.
Yeah, 100%. I mean, starting there, just the whole multi-party aspect, you know, I think about having practiced construction law myself, and I think about, you know, you have your general contractor, the subcontractor, suppliers, you have the owner, you've got insurance companies involved. So you often have a great many parties. So in your experience, number one, do you have any certain strategies that you use in order to try to get as many individuals, as many of these parties into one proceeding as possible?
Yes. Well, I mean, as a practitioner, it really was my goal to try and pick a forum where we could get everybody in, because as a practitioner, you know, our goal always was to try and resolve the problem. And believe it or not, people may not believe this, but you actually can use litigation to try and solve problems. And sometimes the process can help. And so if you can get everybody into one proceeding and get all the insurance companies triggered and involved, that is a good way to then maybe go to a mediation or some dispute resolution process. And you're sort of using the litigation process to help get everybody there so that you have their attention and they're obligated to be there and you can try and resolve the dispute. So as a practitioner, that was always one of my primary goals. But again, in the construction world, that's just not always possible, because as you pointed out, you know, not everybody in that large group or chain of people is necessarily obligated to arbitrate. And so the other thing we did as a practitioner was on the front end of projects. You know, when we were drafting the contracts and working with a developer, I think one of the key things is to try and have a coordinated set of contracts that at least are trying to anticipate that if we do have a dispute, we can try and get everybody involved. You're never really going to be able to get everybody involved, because if there are suppliers at the far end, you know, the supplier of the window or the supplier of some product that is, you know, not a subcontractor, but a supplier to a subcontractor, it's going to be very hard to have your arbitration clause reach all the way down to them, because they're often supplying to a subcontractor on a purchase order that doesn't have an arbitration agreement. But yeah, even with that, you can try and get as many parties up front, you know, by agreement, and have a uniform set of contracts in that way.
Exactly, and that was I think, you know, if you're able to get everyone to agree to the same general conditions and have an arbitration clause that allows for multi-party arbitration, that's all fine and good. But as you state, you know, a lot of times that doesn't happen. So now we are in a situation, let's say as an arbitrator, then do you have any, is it ever possible to maybe get somebody to join an arbitration even though they're not a party to the arbitration contract?
Yes, it's possible. Not necessarily common, but possible. You know, one of the standard contract forms that are used, in particular the AIA contract forms, it's interesting. They were drafted by architects, and the standard form terms don't require the architects or the design team to necessarily be part of an arbitration. Okay. And that is a real issue. Now, sometimes people change that again up front in their contracts. They'll change that provision to try and make sure that everybody can be involved, because particularly if I'm representing an owner, if there's a construction problem, there's the typical situation where the design team is going to say it was the construction and the construction team is going to say it was the design, and you kind of need both of them in the proceeding so that you can hash it out and find a way to resolve it. And so there have been times, to answer your question, where, you know, we'll be in that situation and we'll reach out to the design team and ask them if they would participate in the arbitration. Sometimes they would, but I have to say, as a general rule, a lot of times they won't, because, you know, strategically it may not make sense for them to make it easy on the owner to bring them into the dispute.
Right. So how about, though, what about the issues regarding estoppels? So we've been hearing a lot in the news ever since the Supreme Court had a recent decision, the GE case, that where they allowed for the use of common law estoppel to maybe bind a third party to arbitration. Maybe talk about how estoppel could possibly come into play in a construction situation.
Yeah, it's really one of the most interesting areas, and one that is not all that well known, because, you know, going back to what we were talking about earlier, arbitration is a matter of contract. And so you would think that if you weren't a party to the contract, that you can't be forced to arbitrate or be bound by an arbitration decision if you weren't part of the arbitration. But in fact, this estoppel concept is pretty well established, and it works in two very distinct ways that are both not necessarily obvious, I don't think. They weren't obvious to me. So take, for example, a situation where student housing development was built. And the original developer, they build this gorgeous student housing because, unlike you and me, students today have beautiful housing. And if COVID ever ends, they'll be back in it. And they build this beautiful housing development on a campus, and then they sell it. So the original developer builds this thing, and then they sell it, and it goes to a new owner. And the new owner owns it, and there's all kinds of problems with it. Construction problems, water infiltration, mold, and there's construction issues and design issues. And so the owner, who was never party to an arbitration agreement because they were not part of the original construction contracts, which had the arbitration clause, but they never signed that contract, they may find when they try to enforce essentially the terms of that contract by complaining about the quality of the construction, they may find under estoppel principles under state law that they're actually obligated to arbitrate because they're trying to enforce a contract that had an arbitration provision. Even though they never signed it, the fact that they're trying to bring claims that are relying on the terms in that contract can require them under estoppel law in most states to arbitrate if the other side insists on it. And
yeah,
so, go ahead, I'm sorry.
Oh, I was just going to say, I agree with you, though. This estoppel area is really rich and interesting, and sort of trying to tease out what the actual rules are. I mean, I think the way you stated, though, was really well stated, where you're relying on, I know often the cases we'll talk about where it's intertwined with, right? So where the issues are so intertwined.
Yes.
But then again, that's kind of a danger in the sense that you don't know for sure whether estoppel is going to apply in certain circumstances because it is an equitable principle. Yes. So I think there's how you sort of manage that situation. I guess you could use it as kind of a carrot to get somebody to join an arbitration, perhaps, because there's a concern that estoppel may apply if they don't participate.
Yes, and it can be problematic for an owner. You know, this new owner, they buy this student housing thing. They have these problems. Now, this is actually out of a case. There's a 2018 North Carolina case. And what happened was, you know, kind of like what I would have done as a practitioner, is the owner then sued everybody. Okay, they sued the general contractor, the design team, all the subs, everybody they could sue. But what happened was two of the parties who had arbitration clauses in the original contracts insisted on arbitration. And the owner said, no, I never signed an arbitration agreement. And the court held, no, you have to go arbitrate against those two parties because you're trying to enforce a contract essentially that had those arbitration clauses in them. Well, what happened was it was kind of a nightmare scenario, because what happened is that owner was forced to go arbitrate with those two parties, but everybody else was back in the lawsuit. And so now they've got two different forums going, and they're probably, some of the factual issues are going to be the same, but they're going to be tried in different forums. And the timing of that and how that's all going to work becomes very gray and very unique to the case and expensive.
Well, and then the application of issue preclusion, I imagine, gets pretty hairy, because
Yes.
you're really going to have to be very sort of intricate in showing that issues were actually argued and decided.
Yeah, I mean, so this is the other side of the coin on the estoppel issue. So on the one hand, here's this, I mean, I'm sort of feeling for this owner here. Because this owner, they wanted to try and, have everybody in one proceeding and can't. So now they're going to go arbitrate against these two parties. And then there's another piece of estoppel that could apply here. So suppose that owner's in the arbitration and they actually have a factual issue about the cause of the water infiltration, in these units. And they go through a full hearing, and it's determined essentially in a way that is not good for the owner. Okay, that it's just determined in a certain way by the trier of fact, the arbitrators. If that owner then tries to go after one of the subcontractors, okay, who was involved in the work that was done that caused the water infiltration allegedly, if it was determined in that arbitration that it was not that subcontractor's bad work that caused the problem, there's going to be estoppel against that owner when he tries to sue outside of the arbitration that subcontractor on that same issue. Because it was already determined in the arbitration and the owner had a full opportunity to try that issue, and the arbitrators held that no, that subcontractor's work wasn't bad. The owner is not going to be able to relitigate that issue against the subcontractor, even though it's never litigated the issue directly against that subcontractor.
So to play devil's advocate, though, why do we think that the owner should be able to relitigate that issue?
Well, I mean, it's a fair question. I mean, and maybe he should. Maybe he should. But it's kind of a shame, because it's really not a good situation with the owner, because if the owner had won on that issue, okay, if the owner had actually proven against the general contractor in the arbitration that the water infiltration was caused by the bad work of one of the subs, the owner would not be able to use that good ruling in a separate proceeding against the sub, because the sub never had a chance to defend against the claim in the arbitration.
Yeah, that I think that really does make sense, because then of course the sub is going to say, well, I never had an opportunity because I wasn't part of that arbitration, so I didn't get to present my evidence. Yeah, and I do think, sort of getting back to the multi-party aspect, there's a lot to be said about getting everybody in one place to try to promote settlement as well. So I wonder if you could speak a little bit to that issue and kind of your views on how that can really be part of an overall problem-solving regime. Thinking about how you can really solve a problem, as you said.
Yeah, well, no, absolutely. And putting on my mediator hat, that's something that a mediator can do, and it gets complicated. But there are, what you can do is, if you do have one of these very messy situations, the good thing that a mediator can do is try and essentially create that forum for everybody, the mediation process. Now, mediation is also a creature of agreement. And so, getting everybody to agree is sometimes the initial big hurdle. Oftentimes the contracts require mediation, and so you will have some group of parties that are required to mediate. But what I like to do is, if you can actually, and in the construction world, people actually, mediation is pretty favored. So it's not impossible to think about getting everybody into a mediation to try and resolve. And then what the mediator can do is, like I said, create that forum. And particularly in construction, what we do is we really try and make it a pretty informative process. It's not like we just have an agreement to mediate and get together one day with 6 parties and a complicated set of facts. As a mediator, I get very involved, and most construction mediators get very involved before the mediation to really work with the parties, understand their positions, and try and create a process that could allow you to get to resolution. You know, you may tier this thing. You may initially have the owner dealing with certain parties, you know, and certain exchanges of information. You may have public proceedings, you know, not public, but public to the mediation, where you actually have live presentations from various parties to try and educate everybody about their positions, let the insurance companies in the background see those positions. And so, you know, the process, what I love about mediation is the process can be just about anything that you think would help move you forward towards resolution.
Right, right. Well, and actually getting kind of to more of a concrete example, I know you actually did arbitrate a multi-party dispute, I guess with 5 or 6 parties, was it, recently? And maybe you want to speak a little bit about how you managed, because even like you said, you wanted to be informative. So right there, I think about, well, how do you manage the exchange of evidence? How do you manage? So maybe if you want to speak to your experience recently.
Yeah. I mean, it was a really interesting case because it happened right at the beginning of the COVID pandemic. And so we were actually in St. Louis the first 2 weeks of March as it was just really becoming live. And we had live hearings in St. Louis for 2 weeks, sort of normal. And then we had to go to 3 weeks of Zoom hearings, which actually went surprisingly well. I never would have thought it went as well. And I think what we tried to do is the panel in that arbitration, we really tried to keep the proceedings focused and to not require all of the parties to be there all the time. And so, you know, we had claims where it was the owner against the general contractor. And if a particular subcontractor's work was at issue in a particular claim, I mean, in that crazy case, we literally had about 65 different things that were wrong that were being arbitrated, okay? So if a sub was actually involved in a particular issue, then that day we would have them there and they would actually put their evidence in at the same time so we could sort of get all the evidence on a particular issue in place so the panel could have that, and then we move on to the next issue. And in a defect case, I think that's a good way to do it.
Oh, yeah. And that, I think, sort of brings us full circle as to why arbitration is so popular in the area of construction, because you have that ability to create these little pods around issues. And that is tremendous because that doesn't really happen in litigation.
Yes.
So I think the way you can sort of orchestrate how it all works around the particular issues, and of course having expertise in construction law. Did you have, by the chance with this recent example, was it 1 arbitrator or did you have 3?
No, we had 3, and it was a great panel. And I have to say, you know, I mean, one of the knocks on arbitration is, particularly in a complex case, that you have to pay for the panel. And the panel, you know, and so you've got 3 arbitrators that you're paying for. You don't have a free judge. But I have to say that, you know, that hearing went 5 weeks between the Zoom and the live. And that case, with all of those claims in court, I think would have gone months and months. You know, we were able to cut through and streamline the presentation of evidence in a way that just was not possible in a court. And I think the parties had confidence that the arbitrators were going to get it and that they didn't have to present the evidence in quite the same way. It could be a little bit more summary, I guess. And it was a much more streamlined thing than it ever would have been in court.
Yeah, I actually remember arbitration being fun in construction to the extent that we could have, you know, regular like evidentiary exchanges, and we had like, we would put together books of each issue, and it was just kind of more about getting to the answers and getting to a decision.
Yeah.
And of course, we would always have an architect or engineer who was one of the arbitrators, which of course helps with the expertise and having someone who really understands what they're looking at as far as like blueprints or kind of getting to the bottom of defect claims.
Yes. Yeah. One of the things that was really interesting, just as a practical matter on the Zoom hearing, was I was impressed with the ability of the Zoom platform to allow the parties to blow up documents. And so you have a document that's put up on the screen, and the key thing, the absolute key thing, was that there was a person who was the document person. He was with a reporting company, but he was very good and he had all the documents. And just like in court, the counsel would say, pull up, document XYZ, and it would come up, and then counsel could actually draw right on the Zoom platform. He could actually draw a circle around what he wanted to highlight. And so even if we had a drawing with details, and it's a very intricate drawing, the operator for the documents was able to blow that up, and we could see it very clearly. All of the arbitrators also, we all had all of the documents separately on a thumb drive that we could pull up separately too. So I had another screen going, for myself. But I got to tell you, it was efficient that way too. Within a few seconds, he could blow it up, and it was not a hindrance. It really was. It was very smooth.
Well, as a longtime proponent who's been working in the area of online dispute resolution for a very long time, I love hearing that.
Yeah, no, I got to tell you, I was surprised because I'm a little old school, and so I'm definitely a convert. I really am. And if I can learn it,
That's
people
good to hear.
my generation can learn it.
Yeah, well, and the thing is, I also believe that the efficiencies and, sort of just being able to be at home with your family and not travel and being able to save all the money, that's, and I mean, that's another cost is when you have an in-person arbitration and you have to pay for the travel for 3 arbitrators.
Yes.
That can be pretty significant. So, so I'm sure that makes a big difference for the clients as well.
Yeah, no, it definitely did reduce costs. I have to say, as an arbitrator, one of the things I missed was, you do go to dinner with your panel, and you do talk, and I think it helps the case when you can do that live. But it did go well. There were also long days in the saddle. Those 8-hour, 9-hour days of taking testimony, looking at the screen instead of being live. It takes its toll on you too. But it's but what I learned is it's very doable.
Yeah, no, but I do get it. There are still benefits to the in-person. Another aspect which I do understand is when you do have an in-person arbitration, there's more allowance and time for counsel to have discussions in the halls and things along those lines that often lead towards settlement.
Yes.
Which is another sort of aspect of being in person. When you're all at one conference center or you're all in one hotel or one law firm, there's those conversations that can happen, which are less likely to happen, I suppose. Although they could, be like, hey, I'll call you later, but it's just not the same sort of casual running into a person.
I think that's a really good point. I think that's actually really critical at mediation. Every mediation I was at, you'd run into the mediator in the hallway and kind of have that side discussion, but sometimes we're critical.
Yeah. Well, gosh, this has been really great. I really appreciate your insights. Really interesting. I do believe construction, arbitration, and mediation are here to stay, and really, really complex, which makes it, I guess, fun for you, I'm sure, as an arbitrator and mediator.
I learn something new every day.
That's the goal, right?
Yeah.
Well, listen, have a wonderful day and enjoy yourself in Chicago.
All right. Thank you so much, Amy.